Hi, everyone. Sorry about that. We're back on. It's a little bit of technical difficulty. So before we get started with the webinar itself, we just wanted to announce a save the date. So March 11th, 2016, we're going to be doing a Campus Clarity Annual Summit, and that's just an opportunity for our clients to get together. We'll have some presentations. It'll be just a wonderful opportunity to share resources, ideas, and implementation strategies around Campus Clarity. If you're interested in finding out more about the annual summit, please just in your question box indicate that you're interested, and we'll follow up with you after the webinar. But it should be a really great event. It'll be held in Indianapolis right before NASPA. So today we'll be presenting on Enough is Enough, addressing New York's new higher education requirements. I'm Pax Haymeyer. I'm an editor here and an instructional writer. And joining me is Karen Peterson, one of our legal editors who focuses on Title IX and other higher education issues. So it'll be about a 30-minute webinar. We're going to start with an overview of the law and the updates that we've done to our courses. And then Karen's going to take over and go into more detail about the updates that we've done, and we'll have some screenshots so you can see the pages that have been affected. Karen will repeat this, but just to say it at the outset, a lot of the changes we'll be showing have been done to our Campus Clarity Think About It courses, but they've also been done to our employee courses and to our other Campus Clarity courses, such as the graduate course, the Campus Save course, adult learners course. At the end, we'll have additional resources, and we can email those out to the attendees afterwards. And we'll have a short recap and wrap-up. And although we know that most of you are existing clients, at the end, if anybody is interested, George Homer, one of our representatives, will be walking through a short demo of the course. So just wanted to set up some of the background and to talk about our general commitment to maintaining courses that reflect the latest legal requirements. So Campus Clarity's parent company is Law Room, which began as an employment side HR sort of answers fax-based service in 1994. And in 2005, it started doing online trainings around compliance issues such as anti-harassment. And we've been training for a long time around those and creating really great courses around those compliance issues. And in 2010, the University of San Francisco was using our employment side course, saw it, and their Vice Provost of Student Life, Peter Novak, thought that it would be a very fruitful collaboration for him and the University of San Francisco to work with us to develop a program for their students around sexual violence and alcohol and other drug prevention programming. And so that's where Campus Clarity and Think About It began. And then as that course was being developed, in 2011, the Department of Education's Office for Civil Rights released the 2011 Dear Colleague letter on Title IX, and that guidance was incorporated into the development of the course. And then after it had launched in 2013, March of 2013, the Campus Save Act passed. And again, our legal team was very active in reading the legislation and incorporating relevant changes into the Think About It program. And then, of course, as you know, there's been a lot of legislation, and it's been constantly evolving. And in 2014, California passed its Yes Means Yes affirmative consent law. We updated our California courses to reflect that. The OCR issued additional guidance around Title IX, and we worked to incorporate that information, as well as in 2015, the final regulations for the SAVE Act. So we've been constantly updating the course, and the most recent update affecting our New York clients is the Enough Enough law. And so our legal team, one of whom is Karen, have been working to read the law, read the regulations, and to incorporate the necessary updates into our courses. So at a very high level, the Enough is Enough law schools must comply with it by October 5th of this year. So if you are if you're a school, if you're a client, just to keep that date in mind. And today, what we're going to focus on, there's a lot that goes into that law about policies, about things like campus climate surveys, but what we're going to focus on the new and ongoing education content that you need to have. In fact, this is one of the interesting distinctions between New York's Enough is Enough law and the Campus Save Act. Whereas the Campus Save Act only requires schools to offer training, New York's Enough is Enough law mandates training for all new students. So that includes transfer students, undergraduates, and graduate students. And so you have to train them around these issues. Now, of course, what our program does is it's going to only be one part of the larger programming that you have on your campus, and what we see the role of our courses as fulfilling, at least especially the base courses, laying a foundation and informing students about these important issues, about the law, and about your policies. There is no Enough is Enough section in the course. This is one of the reasons we wanted to do the webinar. Is what we've tried to do is incorporate the new legal requirements throughout the course in as a seamless way as possible, so that students continue to have a really positive, media-rich experience, and there's nothing sort of distracting. It's just part and parcel of the existing material. And something I already sort of alluded to, but just worth repeating, is we don't make any claims to this course being a silver bullet that will meet all your compliance needs, nor will it, of course, eliminate all kinds of problems on your campus. It must be a part of your larger programming, and this is an important part of the SAVE Act, it's an important part of the Enough is Enough law. But we do offer multiple courses. We have not only the base course, but we have the follow-up courses, the sanction courses. We are currently developing an ongoing course that should be out in the fall of this year that will focus on bystander intervention. So we do have a lot of resources to help you build a comprehensive program and to put one in place. We also have, and we'll touch on this at the end of the presentation, a lot of offline resources, such as posters and sort of presentations that you can use to train students, do live trainings for students, or develop sort of informational campaigns around these issues. So we can help you lay that foundation. And again, today we're just going to highlight the changes and the existing content in our course that help address New York's Enough is Enough law. So with that, I'm going to hand it over to Karen, and she'll be talking in more detail about the updates.
Thanks, Pax, and thank you everyone for joining us today to learn about the steps we've taken to incorporate these new education requirements under New York law into our courses. And as Pax mentioned, we're using screenshots from the Think About It course for students to point out where this new content has been inserted, but many of these pages are shared with our Title IX and Campus Save Act course for faculty and staff, so I just wanted to point out that the information will also be covered on both sides, student courses and employee courses. And what we're going to do is just briefly highlight where the new content addresses the new policies and code of conduct provisions that New York colleges and universities must adopt governing the student behavior, rights, and responsibilities to implement the procedures and protections that are spelled out in these new laws. And so for our purposes here today, we've distilled this down to 10 critical points. And the first point we'll start with is what the main mandate of this law is, and that is to adopt new policies. And so every education program for all the first year and transfer students must include a statement of prohibited conduct. And the requirement to inform students that the institution prohibits sexual and interpersonal violence is already covered, since both Title IX and the Campus Save Act require similar statements. However, this existing statement also informs students that the school's policies apply to all students regardless of sexual orientation and gender identity. The only change we made is to add gender expression as provided in Enough is Enough. But an important feature of this page is that each person taking the course must acknowledge that they read and understand the school's policies linked to the page before advancing in the course. And this acknowledgement helps you comply with the requirement to provide a copy of the rules and policies adopted and that all enrolled students have received a copy. So this leads to the next critical point, which is to give students enough information so they understand what types of behavior are prohibited by these policies. And our courses already include the state law definitions of consent, domestic violence, dating violence, stalking, and sexual assault, which are required by the Campus Save Act. But we've also included potential punishment for these criminal acts, which is required by the recent legislation. And it should also be pointed out that the legal editors here at Campus Clarity track amendments to these laws and also follow new legislation related to the course content. And this is done on a continuing basis so that we maintain the legal accuracy of our courses. And one of the more significant changes to the course, which is required under Enough is Enough, is adding the definition of affirmative consent. And there is a definition that must be included in your school policies that's set forth in the statute, but here on the affirmative consent page, we've summarized highlights of that standard that will be used in your campus conduct proceedings to decide cases involving sexual assault. Affirmative consent is knowing, voluntary, and mutual, and it must be communicated with words or actions that create clear permission to engage in sexual activity. This law also explains when a person is incapable of giving consent due to intoxication, and that the person initiating sexual activity must always get consent, even if they're intoxicated. So we've put this definition of affirmative consent, and also the statute is on all of our important legal terms pages. The relevant statutes are attached so that the person taking the course can always refer to the statute itself. And then we have put the affirmative consent definition together with the state law definition of consent, which is used in criminal cases. And this allows students taking the course to compare these different standards, and that will be helpful so that they can see the differences between being charged with a conduct violation versus being charged with a crime. But a common purpose that runs through this recent flurry of state and federal legislation is to encourage students to report sexual violence. So the next critical point is to provide information on how to report an incident involving sexual misconduct. And here we make the distinction between confidential disclosures and non-confidential reports. Our instructional designer has set up this page in a way that it illustrates the two choices facing a victim or survivor, to report or not to report. And this is some of the most important information in the course. In this introduction to the conduct proceedings page, we point users to the resources tab at the top of the page. And this is where it will tell them how to contact the school's Title IX coordinator if they have any questions, and also find other contact information for a non-confidential report. You see campus police, local law enforcement, online reporting if you have that available. Now, how to find resources in the Title IX coordinator is school-specific information, and this is accessible on every course page, and it can be downloaded and printed by clicking on that little box on the top right-hand corner. This way, a student can save this information away for future reference and doesn't have to go hunt it down. And to help you gather this information, we have an implementation checklist, and this explains the types of information that schools can provide or should provide, and which can also include an explanation of the roles of these key personnel on your campus. and this is where that information will go. The next critical issue is related to reporting, and this is about the confusion around reporting and student confidentiality. So the New York legislation requires schools to explain the difference between confidentiality and privacy. So when you click on student chooses not to report, this is where we explain the option of talking to someone who has a duty of confidentiality. Basically, confidentiality involves licensed professionals, and here we use the examples of therapists, social workers. It can also include medical staff, pastoral counselors, anyone who cannot disclose information they receive from clients or patients without their consent. This is a professional duty of confidentiality. You'll also note to the right that we talk about unlicensed professionals as well. And this is in reference to the Title IX guidance, the question and answer guidance document that came out at the end of April 2014. And it suggested that schools may also designate unlicensed counselors and advocates as confidential resources. And these people could keep reporting students' identity confidential, but they must report the non-identifying information about the incidents so schools can identify safety threats. Now, the next critical point is, what if a student chooses to report? And this is where we explain privacy, and this involves communications a student has with school employees who are not confidential resources. And both Title IX and the New York law provide that reporting students' identity must be kept private to the extent possible, unless the school decides that the student's identity has to be disclosed because it's necessary to investigate a threat to campus safety. This is a tricky area, and I think we can expect further guidance on this and how it should be handled. And in fact, in the Enough is Enough legislation, there's a requirement that implementing regulations will be issued no later than October 5th, 2016. So we'll be certainly hearing more about this. And while we're on this screen, I also want to point out that in the introduction at the top, we explain the student's right to make a police report and be assisted in that process, and that under this new law, New York schools must also provide emergency access to a school official trained in interviewing sexual assault victims. Now, as we go through the phases of the conduct proceedings, we've woven in student rights from the new law. For example, in adjudication, we note that the complainant and respondent both have access to information from the school's investigation and the right to a full and fair record of any hearing. In addition, the accused has the right to be presumed innocent or not responsible, and that the complaint can be withdrawn at any time, though the school may continue to investigate if there's a continuing threat to campus safety. Under sanctions, both students can make statements about what are appropriate sanctions, and either party can decide to disclose or discuss the final outcome. Finally, transcripts notations. This is kind of a hot topic right now. There are several states that are considering similar legislation. It's being called the Scarlet Letter. But the New York law requires that transcripts include a notation that a student was suspended or expelled after being found responsible for sexual violence, or that a student withdrew with conduct charges pending and refused to complete the disciplinary process. Now, during the conduct proceedings, there's also a requirement that interim protective measures be available. And this is another critical point to help students feel safe coming forward. And we've made some minor revisions to this page. The first is in that first paragraph, we wanted to make it clear that the resources are available to all students, both complainant and respondent, and that interim no contact orders might be available if the accused student is a continuing threat. We explained that the Title IX coordinator can provide more information about the types of protective measures that are available, and we also, once again, up in the resources tab, make available information about on and off campus support and services, which can also be downloaded and printed. And this is where schools will provide us the information for these services and how they can be contacted, and the student can find that information there. Another critical point under this New York law is that protects students and encourages them to come forward are the Amnesty policy and the Student Bill of Rights. And we have placed these under the Victim Protections page, and under Victim Protections, we talk about state laws on available protective orders and restraining orders for victims of domestic and dating violence. Some states also make these protective orders available for victims of stalking and sexual violence. And we've added the summaries of the Amnesty policy and Student Bill of Rights here. The Amnesty policy strongly, and that's their word, strongly encourages victims and bystanders to report sexual and interpersonal violence. And this policy will offer immunity from conduct violations for alcohol or drug use at or near the time of the incident to victims and bystanders who come forward in good faith to report incidents of sexual or interpersonal violence. In addition, the Student Bill of Rights provides important victim protections, and we've summarized those here, including the right to be treated with dignity, not be blamed, receive help from campus police or security to request a protection order, and in situations where there is a continuing threat to campus safety, the accused may also be subject to an interim suspension. And we have the relevant statutes attached that can be accessed through that link at the bottom of the page. So with that, I'm going to turn it back over to Pax, and he's going to talk about the last two critical points.
So one of the other requirements of the New York's Enough is Enough law is to include information about the long-term costs of sexual violence. So we already include a lot of information about the consequences of sexual violence, but we looked at this as an opportunity to explore it more fully. And so what we put together was a series of 3 pages that explored the costs at 3 different levels: the individual level, the community level, and so these are people who are supporting the survivors or friends and family immediately around the survivors, as well as the societal level. And this here we have some high-level statistics from the CDC and some researchers about the financial costs of sexual violence, as well as some information about the way it affects our values and beliefs as a society. I also want to jump back for 1 second, and you see the red arrow down in the lower right-hand corner. We've also included direct links to some of the resource information that Karen has been talking about on these pages, because we felt that students who are reading them who might have experienced sexual violence might want to review reporting information or the support and services available to individuals, or as well as the community members who are supporting victims and survivors. And so we felt that it was important to embed this information in the page. So students can click on those buttons at the bottom, and it will pull up that same resource information that they can access at any time on any page in the upper right-hand corner of the course. We already had a lot of this information in the employee courses, so we have not included these pages there, but we do have versions of these 3 pages in the graduate course, in the Think About It base course, and the Campus Safe course, the Adult Learner, and community college courses. So in addition to the long-term costs, the New York's law requires training around bystander intervention and risk assessment and reduction. Now this is something that's already covered by our existing content, and right now I have a page from our base course on the bystander intervention, and we have a lot more information on it there. We also cover it extensively in our follow-up courses. We have sanction courses. We've also recently hired someone with a lot of experience and expertise around implementing bystander intervention at universities, and she's been working hard in incorporating it to a greater extent into some of our courses. We're working on developing an ongoing course that should be available this fall that will focus on bystander intervention. We have some workshop materials around it. And it's also something that we think is valuable and important to include in our employee courses. So this year when we updated our anti-harassment courses for all employees, including higher education and corporate clients, we included a lot of information and skill development exercises around bystander intervention. Additionally, we include a lot of information about recognizing the signs of interpersonal violence, sexual violence, sexual assault, substance abuse problems. And so we have a lot of informational pages around that help students identify and recognize those issues, as well as exercises that ask them to apply that knowledge in realistic scenarios. And we also provide valuable information to students about reaching out to a friend or a colleague who is experiencing interpersonal violence or sexual violence. And again, we have interactions that help them apply and really consolidate that knowledge. The New York law also requires schools to address the role of alcohol in sexual violence, and this is something that has been part of our program from the beginning. When Dr. Novak approached us about developing Campus Clarity, he wanted a comprehensive program that treated substance abuse and sexual violence all together. And so from the beginning, we've addressed this issue. I have a screenshot from one of our videos on the page, and this is something we include in our follow-up courses as well. So those are the 10 key points that we've addressed in our course, either through existing content or through updates to our content. So just to run through them briefly again, especially if you've joined us a little bit late, there's a statement of prohibition that goes on our policy page. The one big change there is that we state that these policies apply regardless of gender, sexual orientation, or gender expression. We include and have included the relevant state laws. We have updated our consent page to include the New York's definition of affirmative consent. We have incorporated the new reporting. We have extensive, and Karen pointed out this is some of the most important information, of course. We have an extensive infographic on reporting information, and we incorporated relevant New York changes there. We have an explanation of confidentiality versus privacy. And as Karen mentioned, we can expect further guidance along those issues, and we will be updating our courses as that guidance is issued. Information on responses to reports and sanction information. Interim protective measures available both to the respondent and complainant. Amnesty policy and the Student Bill of Rights, which we've included under our victim protections section. The long-term cost of sexual violence, and the bystander intervention and risk assessment reduction, which has from the beginning been an important part of our course. So in terms of the update schedule for our clients, again, as we said at the beginning, schools must comply by October 5th. So we're going to update existing courses by Friday, October 2nd, unless we hear otherwise. So a lot of schools have already launched, have already trained their students, so we're not going to just update them willy-nilly. So we've set this as a date that should give us ample time to incorporate those changes into everyone's courses. If you want them included earlier, please reach out to us. We're happy to do it. It should only take us a day or two to put them into the course, if not less time, and so you can have them, as soon as possible. If you do want to do that, please reach out to our Campus Clarity team. You can see their contact information at the bottom. Any new courses that we build will automatically include the updates. So if you're a new client and we haven't created a course for you to review, then when you do get it, it will include these updates in it automatically. Finally, as Karen pointed out earlier, there are going to be new regulations around this issue on October 5th, 2016 of next year. And so you can expect a sort of second round of this update. We have a question. I just with the transcript. So we have a question about, can you please reiterate what the transcript needs to notate per enough is enough? Karen, is that something you want to answer now, or is that something we should get back to?
Well, I'll answer with the general information I gave in the presentation. I don't have the section number right at my fingertips right now, but transcripts, if a student is found responsible for sexual violence in a conduct proceeding and is suspended or expelled, that will be should be noted, must be noted on their transcript. And also, if a student withdrew with conduct charges pending and did not continue in the disciplinary process, that would also be noted on their transcript. Now, there are provisions in the new law that would that address circumstances where those notations can be removed. For example, when a suspension is completed, I think it's a year after the suspension is completed, a notation can be removed. So I'll get the section number for you, and I can provide that, and you can look to the statute itself for the details around how that's treated after a notation is made, and if the punishment has been or the sanctions have been satisfied, if that notation can be removed at some time later on.
So, in fact, to follow up on that, we also have additional resources, our blog and our website. I know we're running a little bit over in time, and I apologize for that. We had the technical difficulties at the beginning, and we appreciate your patience. So we'll send out this information in a follow-up email to everyone who is attending. But we have resources on our blog and on our website, and so we have free resources. These are some of the things we're talking about in terms of posters and presentations that you can use. On our blog, we have information, and if you go down, you see the second to last blog post is on the New York updates. I believe there's a link to the statute there, so you can look for that information and more there as well. Also, one of the requirements of the law that we didn't mention is outreach to parents. And so fortuitously, we recently did a webinar with Peter Novak and Barbara Thomas of the University of San Francisco on USF's outreach to parents. And so if you want to see that webinar and some of the resources that we linked to and provided around that, including a sample welcome letter that USF sends out to its parents of incoming students, you can go to the third URL there, which should take you to our webinar. But you can find a lot of information, a lot of valuable resources on our website and on our blog. And as I said, we'll follow up by sending this out to our attendees.